Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGinnis Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. In this channel, I try to provide educational and informative content about Canadian privacy and technology law. A couple of weeks ago, I discussed the intersection or collision of privacy laws and freedom of expression, particularly with respect to news reporting. Today, I'm going to pick up on that topic and discuss privacy in the open courts in Canada. This is also a pretty big topic and one that is still undergoing significant development. I'm going to start with my usual disclaimer. This is intended to be a relatively general overview of the law for educational and informative purposes only. This is a complicated area of the law with many nuances. I'll be talking about general rules, but there are always exceptions to those rules. If you have any specific legal questions or if you are dealing with a situation yourself, you should seek qualified legal advice. All opinions that I express are mine and mine alone and should not be attributed to my law firm or any of its clients. And of course, I'm only talking about the law in Canada. Privacy laws, freedom of expression laws can vary significantly from jurisdiction to jurisdiction. Most of us would be familiar with the idea of freedom of expression or freedom of the press. In Canada, it's one of the fundamental freedoms guaranteed in Section 2B of our Charter of Rights and Freedoms. This section reads, "Everyone has the following fundamental freedoms: freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication." In Canada, we regularly talk about freedom of expression, which is guaranteed to everyone. It does include, of course, freedom of the press. So freedom of the press is not its own thing. It says everyone. All Canadians, including the press, have those rights. But the media are often the eyes and ears for the rest of us, particularly when it comes to what happens in our courts. So in understanding how Section 2B works, we also have to understand that this right is not absolute. The freedom of expression guarantee is subject to Section 1 of the Charter, which allows some limitations on Charter-guaranteed rights. So Section 1 says, "The Canadian Charter of Rights and Freedoms guarantees the rights set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society." Let's break that down. Charter-guaranteed rights can be subject only to reasonable limits, and those have to be prescribed by law, and they have to be demonstrably justified as compatible with a free and democratic society. And it's always up to the government to justify these limitations. If they put a limitation in a law, they have to stand behind it. It's important to note that freedom of expression not only includes the right to express oneself, but the courts have found that it includes a right to receive information. So limiting a journalist's right to report on something also limits the public's right to receive that reporting. In the last video in this series, I discussed how the Supreme Court of Canada has given us a test for how to determine if an infringement of a charter-guaranteed right can be justified under Section 1. This is called the Oakes test, from a 1986 decision of the Supreme Court. First of all, the limitation has to be prescribed by law. That's right from Section 1. It could be a federal or provincial statute. It could be a regulation or a bylaw. Now, I'm going to be talking about publication bans later today, and many of the publication bans that come up on a day-to-day basis are written in the criminal code. So they are prescribed by law, and the Oakes test is the test to find out if the ban can be justified. Second, the objective of the law has to be pressing and substantial. The courts will not permit charter rights to be infringed for trivial objectives, so the law has to be for an important purpose. Third, the impact on the charter right has to be proportional, and this has three parts. The means chosen by the legislature to address these objectives must be rationally connected to the objective. So in doing so, the measures need to minimally intrude on the impairment of the rights at issue. And then finally, there must be ultimate proportionality between the infringement and the objective. This is the final balancing step. In order for an infringement of a charter right to be justified, the government has to satisfy all parts of this test. If it fails one part, its justification fails. In a democracy, the open courts are critical for trust and transparency. Except in the most extreme circumstances will we tolerate justice being done in secret. The Supreme Court of Canada, as recently as last year, in a case I'll discuss in greater detail called the Sherman Estate, said, "This court has been resolute in recognizing that the open court principle is protected by the constitutionally entrenched right of freedom of expression, and as such, it represents a central feature in a liberal democracy." As a general rule, the public can attend hearings and consult court files, and the press, the eyes and ears of the public, is left free to inquire and comment on the workings of the courts, all of which helps make the justice system fair and accountable. The Open Courts principle is rooted in Section 2B of the Charter and is fundamental to our democratic system of government. But as I mentioned before, Section 2B is not absolute, nor are the open courts. But any limitation on the open courts has to be justified. A really good illustration of this is a case called Canadian Newspapers in Canada from 1988. In that case, a media organization was challenging a mandatory publication ban from the Criminal Code, arguing that it could not be justified under Section 1. The Criminal Code makes it mandatory for a judge to issue a ban on publishing anything that would identify the complainant in a sexual assault case, if the prosecutor or the complainant asked for it. So if one of them asks the judge for it, it has to be ordered. There is no discretion. So clearly that limits the Section 2B rights of the media to report the news. You'll recall that as part of the Oakes test, the limitation has to impair the right as little as possible in order to accomplish its objective. So how does a big sledgehammer like this impair the freedom of expression right as little as possible? The judge has no discretion to consider whether the order is necessary or appropriate. On its face, it may look like the rationale of protecting the identity of the complainant is to protect the privacy of the complainant, but it's more complicated than that, but still rooted in the effect of that privacy interest on a larger societal goal. Recall that in order for an infringement of a Section 2B right to be justified, it has to be A, prescribed by law, B, there has to be a pressing and substantial objective, and C, there has to be proportionality. This ban is in the Criminal Code. It's not vague, so it's prescribed by law. So in order to determine whether the objective is pressing and substantial, we have to figure out what the objective is. On its face, it looks like it's there to protect the privacy of complainants, which can be a good in and of itself, but likely not enough to justify a limit on the open courts. But the objective is actually more than that. The court concluded that of the most serious crimes, sexual assault is one of the most underreported. The main reason stated by those who do not report this offense is fear of treatment by police or prosecutors, fear of trial procedures, and fear of publicity or embarrassment. So victims of sexual assault often do not come forward because the fear of publicity and embarrassment associated with how the justice system works and how trials are reported on. The objective of this measure is to give victims confidence that if they do report sexual assault and they fear the publicity, they know they can request and they will get a publication ban that will protect their identity. There's no doubt in their mind at that stage. Encouraging victims of sexual assault to come forward is important to the justice system, and that is important to society. This, the court concluded, is a pressing and substantial objective. But what about the minimal impairment test? How can an automatic, no discretion publication ban impair the right as little as possible? Well, it has to impair the right as little as possible in order to achieve its objective, which is to remove the barrier that results in the underreporting of sexual assault. The court said, obviously, since fear of publication is one of the factors that influences the reporting of sexual assault, certainty with respect to non-publication at the time of deciding whether to report plays a vital role in that decision. Therefore, a discretionary provision under which the judge retains the power to decide whether to grant or refuse the ban on publication would be counterproductive, since it would deprive the victim of that certainty. Assuming that there would be a lesser impairment of freedom of the press if the impugned provision were limited to a discretionary power, it is clear, in my view, that such a measure would not, however, achieve Parliament's objective, but rather defeats it. Also, on the topic of minimal impairment, the court noted that the provision is pretty fine-tuned. It doesn't close the courtroom, it doesn't close the court files. The public and the media can still attend in court and see that justice is done. The media are able to fully report on every aspect of the case and the trial, as long as they do not identify the complainant in doing so. In the final balancing in this case, the court determined that this infringement was justified as being for an important purpose, and it was ultimately proportional. So in this case, we had our limitation on one of our most important values and democratic principles justified because of a privacy interest. It wasn't because protecting privacy is a good thing in and of itself, but because the impact of reporting on sexual assault cases affects victims' privacy interests, which inhibits reporting, which is bad for our society and bad for the administration of justice. We'll see as we go along that privacy on its own is seldom sufficient to justify a limitation on freedom of expression or freedom of the press. The privacy interest engaged has to be connected to a broader public interest. What was at issue in the Canadian newspapers case was a publication ban written into the criminal code, something that's referred to as a statutory publication ban. But courts in Canada have a common law and inherent jurisdiction to issue publication bans from time to time. These will similarly affect freedom of expression and the open courts principle. The Oakes test was designed to test whether a legislated limitation on a charter-guaranteed right can be justified. The Supreme Court of Canada, starting in a case called Dagenais, formulated a very similar test to determine whether a common law publication ban can be justified. This has been dramatically expounded upon in the Sherman case, which I'll also discuss. In the Dagenais case, there were a number of individuals who were former and present members of a Catholic religious order who had been charged with physical and sexual abuse of young boys who were in their care at training schools in Ontario. Around this time, there had been a lot of publicity and public outrage related to widespread sexual abuse at orphanages and church-run schools. Because of this interest, the Canadian Broadcasting Corporation created a mini-series called The Boys of St. Vincent, which was a fictional account of sexual and physical abuse of children in a Catholic institution based in Newfoundland. The accused individuals were concerned that any broadcast of this miniseries would affect their right to a fair trial, particularly focusing on the impact the broadcast would have on potential jurors. So they went to the Ontario Court of Justice, asked for and obtained a broad injunction prohibiting the CBC from broadcasting the miniseries anywhere in Canada until the conclusion of the trials. They also got an order prohibiting publication of the fact that they'd even applied for the order and prohibiting discussion of any material that's filed in the court file in association with this application. Extremely broad. Now, on appeal, the Ontario Court of Appeal scaled back the injunction to limit it to broadcasting in the whole province of Ontario and one English language television station in Montreal. It ultimately made its way up to the Supreme Court of Canada, where that court had its first opportunity to consider common law publication bans in the age of the Charter. In this case, it could be framed as the defendant's right to a fair trial, guaranteed under the Charter, against the CBC's right to broadcast the production, which is also guaranteed under the Charter. Until this time, the fair trial right almost always trumped the freedom of expression right. The Supreme Court of Canada, in this case, concluded we don't have a hierarchy of rights in the Charter, so there's no automatic assumption that one right will prevail over the other. They have to be determined to coexist. So in order to guide judges on whether a publication ban should be granted at all, and if so, what it should look like, the court fashioned a test that is clearly similar to the Oakes test. The court said a publication ban should only be ordered when such a ban is necessary in order to prevent a real and substantial risk to the fairness of the trial, because reasonably available alternative measures will not prevent the risk. And the second part, the salutary effects of the publication ban outweigh the deleterious effects to the free expression of those affected by the ban. So the objective must be pressing, related to a risk that is real and substantial, and related to the administration of justice. The limitation has to be very carefully tailored, and really only as a last resort. So if there are other things that can be done to mitigate the real and substantial risk to the administration of justice, or in this case, the fairness of the trial, those measures have to be taken before resort is had to limiting someone's freedom of expression. So applying this test to the four accused in Dagenais, the court said the publication ban should not have issued because there were other alternatives reasonably available to protect the fairness of the trial that did not impact the CBC. That could have been including adjourning trials, changing venues, sequestering jurors, allowing challenges for cause, and also providing strong judicial direction to the jury. I was involved with my colleagues in my firm in a case a little while ago that engaged these issues. We took it to the Supreme Court of Canada pro bono because we thought it was a very important case and a very important issue. That case is called AB and Bragg Communications. So one day, a 15-year-old young woman woke up to find that someone had created a fake Facebook account using her name and her photo for the profile image. The account started sending friend requests to AB's actual friends, and then started posting some pretty gross sexual stuff about AB that she herself would never have posted. So we went to the Supreme Court of Nova Scotia to get something called a Norwich order in order to identify who was behind this fake account. We also asked for a publication ban on the identity of AB and banning publishing the contents of the posts from the fake profile. AB did not want to proceed with the court case if she would be named and was then associated with the gross postings. We didn't get a publication ban because the media argued, and the court agreed, that she would have to prove that her mental health would be adversely affected if she did not get the ban. We appealed all the way to the Supreme Court of Canada, where a unanimous court said, "The girl's privacy interests in this case are tied both to her age and to the nature of the victimization she seeks protection from. It is not merely a question of her privacy, but of her privacy from the relentlessly intrusive humiliation of sexualized online bullying." The court then went on to say, "Recognition of the inherent vulnerability of children has consistent and deep roots in Canadian law. This results in protection of young people's privacy under the Criminal Code, the Youth Criminal Justice Act, child welfare legislation, not to mention international protections such as the Convention on the Rights of the Child, all based on age, not the sensitivity of the particular child. As a result, in an application involving sexualized cyberbullying, there is no need for a particular child to demonstrate that she personally conforms to this legal paradigm. The law attributes the heightened vulnerability based on chronology, not temperament." The court then connected this individual interest to a broader societal interest similar to that in the Canadian newspapers case. The court said, "In addition to the psychological harm of cyberbullying, we must consider the resulting inevitable harm to children and the administration of justice if they decline to take steps to protect themselves because of the risk of further harm from public disclosure. If we value the right of children to protect themselves from bullying, cyber or otherwise, if common sense and the evidence persuade us that young victims of sexualized bullying are particularly vulnerable to the harms of re-victimization upon publication, and if we accept that the right to protection will disappear for most children without the further protection of anonymity, we are compellingly drawn in this case to allowing AB's anonymous legal pursuit of the identity of her cyberbully." That was the first side of the analysis related to the interests protected by the ban we were seeking. For the second side, the negative impact on freedom of expression, the court concluded that allowing AB to proceed under a pseudonym had a minimal impact on freedom of expression. Nothing prevented the media from being present at the hearing and reporting the facts of the case or on the conduct of the trial. Only information likely to reveal the complainant's identity is concealed from the public. And once her identity is protected, the court said that restricting access and reporting about the fake profile was not necessary, and that couldn't be justified. So you've seen that up to this point, when privacy is set against freedom of expression, that privacy interest needs to be connected to a broader public interest. Most often that's related to the administration of justice, access to justice, etc. Then along comes a case called Sherman Estate and Donovan, which dramatically changed things. It says privacy can, in and of itself, be a public interest in some cases. Now, figuring out what cases that applies to is the real head-scratcher. The court affirmed that a person asking a court to exercise discretion in a way that limits the open court presumption must establish that 1. Court openness poses a serious risk to an important public interest. The order sought is necessary to prevent the serious risk to the identified interest because reasonably alternative measures will not prevent that risk. And as a matter of proportionality, the benefits of the order outweigh its negative effects. No big change there, very similar to Dagenais. Then the court noted that though an individual's privacy will be preeminently important to that individual, the protection of privacy is also in the interest of society as a whole. Privacy, therefore, cannot be rejected categorically as a mere personal concern. Some personal concerns relating to privacy overlap with public interest. So we've seen that before. This is consistent with AB and also Canadian newspapers. The court noted sensibly that recognizing an important interest in privacy generally would be unworkable. But the public character of the privacy interest involves protecting individuals from a threat to their dignity. Now, dignity in this sense involves the right to present core aspects of oneself to others in a considered and controlled manner. It's an expression of an individual's unique personality or personhood. Okay, so there's normal privacy that doesn't get to trump freedom of expression, and then there's dignity privacy, affecting dignity that may in some cases. The court then says privacy is predicated on dignity will be at serious risk only in limited circumstances. Neither the sensibilities of individuals nor the fact that openness is disadvantageous, embarrassing, or distressing to certain individuals will generally on their own warrant interference with court openness. Okay? Then the court concludes that dignity will be at serious risk only where the information that would be disseminated as a result of court openness is sufficiently sensitive or private such that openness can be shown to meaningfully strike at the individual's biographical core in a manner that threatens their integrity. The question is whether the information reveals something intimate and personal about the individual, their lifestyle, or their experiences. So that's very interesting. That's very progressive. But I have no idea where the line is, and the court did not do much to help us find that line. So in the context of the Sherman case itself, the court found that the line had not been crossed, so that privacy could not be used, in this case to shield court documents from public view. I really have no idea what to do with that. I think it will take and make a whole lot of work for lawyers. So far, there are 49 cases on the Canadian Legal Information Institute citing Sherman and including the word dignity. And recently, there's a bizarre story out of St. John's, Newfoundland and Labrador, where a lawyer charged with sexual assault is seeking a publication ban to protect his identity based on the Sherman Estate. He was unsuccessful in the lower court and is apparently appealing his case to the Supreme Court of Canada. Who knows? So privacy can certainly collide with freedom of expression and freedom of the press. Generally they'll coexist. Run-of-the-mill privacy isn't enough to justify an infringement of freedom of expression, but when it's connected to the administration of justice, access to the courts, or where it engages human dignity, the calculation can change. Unfortunately, I don't have the formula to do that calculation, and it appears that nobody else has that formula. It's being hammered out in the courts on a case-by-case basis. Thank you very much for tuning in. If you found this to be of interest, you'll likely be interested in my discussion about privacy laws in the media. I'll link to it below. If you have any comments on this discussion or any suggestions for other topics you'd like to see discussed, please leave them in the comments below too. I read and reply to them all. And if you find this sort of content to be interesting or informative, please subscribe. If you also click the bell, you'll be notified of any new videos as they're posted. And of course, if you know somebody else who may be interested in this topic, feel free to share it with them. Thank you very much.